The gentlelady, Ms. Hageman from Wyoming, for 5 minutes.
Mr. Chenoweth, it is good to see you again, and I appreciate your testimony and your correcting the record from the gentleman from Georgia in terms of the actual facts and legal situation we're facing in this country. NCLA has been at the forefront of these issues and done excellent work in exposing the unconstitutionality of much of the administrative state and the erosion of our constitutional foundation. I'd like to focus on this experience to demonstrate how the administrative law courts and ALJs and ALCs are facilitating the abuse and overreach of these federal agencies. Do federal agencies have incentives such as higher chance of success or procedural benefits to pursue enforcement actions with an ALJ versus an Article III court?
Well, they absolutely have higher rates of success, as Mr. Alt mentioned earlier. We have those numbers specifically at the SEC, which he shared with the subcommittee. I don't have figures at some of the other agencies, but we certainly know that these agencies tend to pursue sort of cases more aggressively in their own courts with novel theories that they know that they couldn't get past a district court judge.
Well, and the administrative law judges are actually part of the very agencies who are the party pursuing the enforcement proceeding. Isn't that right?
That is correct.
Have you ever found any evidence of coordination or work between the ALJs and the agencies in actions that are before the ALJs?
You know, we found a few different things. In my written testimony, I talk about the fact that at the NLRB, for example, the prosecutors and the judges are the same people. They just trade hats on different days. And, you know, I find that to be shocking that you're supposed to, as somebody who's up against, on the other side of one of these transactions, that the person who's prosecuting the next guy in line is my judge and vice versa. That just doesn't seem like a very likely scenario to create fairness from your adjudicator.
Well, then, my experience in taking lawsuits against the federal government is that the federal government and these administrative agencies essentially have unlimited resources to prosecute and persecute citizens in this country, whether they are wealthy or destitute. It doesn't matter. They have unlimited resources. And Professor Mouscott, just real quickly, your testimony references CFPB authority to levy fines at $25,000 a day. Other agencies, such as the EPA, can bring forward daily fines more than double that amount. In fact, right now, the EPA can pursue fines of over $59,005 a day. I recently had a lawsuit where the fines were $37,500 a day for a gentleman who did nothing more than straighten an irrigation ditch on his own personal property, in effect 2.1 acres of land. By the time we went to trial, he was facing penalties of almost $65 million. How can the threat of the imposition of such heavy financial burden on regulated parties further deprive legitimate adjudicative relief for the Americans when they're facing those kinds of penalties?
Well, it's significant authority, as you mentioned, and indeed for knowing violations, the CFPB can impose up to $1 million of penalties per day. So I think, Congress has the power to be able to revisit this situation and make sure that rights are not intruded on in the first instance by simply, in a lot of these cases, taking away the newly given power for agencies to bring charges in their own tribunals. If there's an actual issue and there's been wrongdoing, it can be brought in federal court. It can be established through tried and true historical constitutional processes to protect interests. Thank you.
Ms. Perryman, do you believe that fines of almost $65 million for straightening an irrigation ditch on your property would be a violation of the 8th Amendment to the United States Constitution, being an excessive fine?
I'm not prepared today to talk about a specific hypothetical.
So let's go back to you, Mr. Chenoweth. I think that it shocks the conscience, and I think it should shock the conscience of any person in the United States who actually understands that our government is a government of, by, and for the people, not a government of administrative agencies. So, Mr. Chenoweth, we've discussed the abuses of the administrative state, but it's not just the agency adjudication that is abusive. It's also unlawful at its core. And what I'd like you to do with the remaining few minutes or seconds that I have, do you have any ideas of how we can reform this system so that we do not see the constitutional abuses that we've been experiencing, especially in the last 30 years?
Well, I just really only have time for maybe one idea, which is that imagine how salutary it would be if ALJs only had authority to decide cases when both parties opt into the arrangement. Mr. Nadler expressed concern earlier about not having access to ALJs. You know what, if you want an access to an ALJ, have at it. I'm perfectly fine with that. But you shouldn't put somebody in front of an ALJ against their will, and it would create an incentive for them to behave fairly. It would be more like magistrate judges in federal district court. It would ensure that only cases where significant rights claims were not at stake would be shunted to these ersatz tribunals. I think that would be a really good reform. It's just one reform, but at least it would be an improvement over the status quo.
Thank you very much, and I yield back.